I'm Professor Simon. This is Professor Irish, who's also my husband. As you know, we're going to be teaching the introductory course, the Basic International Human Rights course in Rome. This recording is to teach those of you who have not had any background in international law or comparative law. In other words, those of you who are coming into the second year at this point, a little bit more about the two things that we want to give you some background about. Comparative law first, and then public international law second. And I'm going to hold up the two to display, show and tell things. These are the nutshells for comparative legal traditions and public international law. If you feel like it's a good idea to have either or both of these, you might want to get them from Amazon and get them shipped before you leave for Rome. We will actually be leaving for Rome on Thursday, and we will see you all on Saturday. This is in case you wanted to study up.
Although these areas change very rapidly, particularly public international law, this nutshell was done in 2008, so it's 2007. The other one was done in 2008.
Yeah, you may want to check to see if there are more recent ones than these. In any event, we're going to talk first about comparative law, give you a sense of what a civil law legal system looks like, both from the standpoint of the civil law, in other words, the private law aspects, the contract law and things like that, and then more about public international law. The system of the civil law, and we're going to talk about criminal justice there as well, is very, very different from our own legal tradition. It goes back to the Roman law. The Roman law was really a civil law system, and every sort of civil law tradition, which would be the continental legal tradition, and then the civil law countries that drew on the continental legal tradition, such as their former colonies, French colonies, for example, in Africa, and then also Japan, which has a civil law system, not because it was a colony, but just because it adopted one. It's very, very different from the common law. You've now spent a year learning law in the common law tradition, which is a case-based study of law. In the civil law legal education system, you basically study codes and you study the lectures that your teacher teaches you. You don't use a Socratic method. You don't learn to read cases except very seldom as you get further on in your law studies. But it's basically a code-based system. A civil code, so the code that governs a civil law country, is essentially a very broad code. It covers a number of different topics, such as what we call torts, contracts, marriage, and other kinds of family matters. There are frequently commercial codes, commercial laws, in addition to the civil code. Just as we have in this country, we have contract law. But there's contract law in the civil code, and then there's the commercial code. And then there's always a a criminal system. With respect to the other aspects of civil law that we're not going to talk about today, there is public law. Now, public law is the kind of thing that we talk about as administrative law. So it's the relationship between individuals and corporations and the state. But that's really not a particular interest to you as people who are just learning about these systems, because when we go to the courts in Italy, we will be attending court in a civil court, and we'll be attending a criminal court, I believe. That's what we did the last time. So with respect to the civil law, it's important to know that although there is a civil code that is very basic and very broad, that covers a variety of different items, those items are now frequently dealt with in more specifics by specific legislation. They aren't all, but many of them are. So for example, the marriage law in a particular country may be much more specifically dealt with in a new code of the marriage law that's sort of below the civil code. The civil code being, in effect, an umbrella law, and you just hang other pieces of legislation on it. And then with respect to disputes, to private law disputes, contract disputes, property disputes, things like that, those are litigated in basic civil courts. There are judges, and we're talking generally because you'll be hearing specifically about the system in Italy when we're there, but they're litigated in courts that are like our courts. But the thing to remember, both with respect to the civil law and with respect to the criminal law, is that there is no system of precedent in the sense that we have it. Now, that doesn't mean that judges are unaware of the way cases have been decided by other judges. Of course they're aware of that. And there are compendia published of decisions in particular cases. So obviously judges can have reference to how other judges may have interpreted a specific clause as applied to a specific situation. But there's no precedent, so that you can't expect to have every case decided exactly the same if the facts are fairly close to being the same. That said, however, there is a great deal more movement towards uniformity of legislation with regard to specific topics in the European Union, which means that because of the movements to try and say, for example, have a similar contract law throughout the European Union, you find a great deal more uniformity now than there was, I would say, probably about 20 to 25 years ago. Very similar to what we do in the United States with the commissioners on uniform state laws and things like that. So there's an attempt to make things more similar than they were in the past, specifically with respect to the civil law. With respect to the criminal law, that's where the differences, I think, are the most apparent. First of all, they don't use a jury system. Now, many jurisdictions in Europe are in fact moving in the direction of putting some lay people into the decision-making process. They don't, people don't try cases to a jury, they try cases to a judge. But there's an even more significant difference at the beginning of a trial process, and that is that you have a very close relationship between the prosecutors and the police in making a case, and then you have a very close relationship between the prosecutor and the judge who is the inquiring judge. Now, you've never heard of that in our system, but it exists in civil law countries. And this is the judge, not the trial court judge necessarily. It may be, but not necessarily the trial court judge. But the judge plays a role in the building up of the case. And so you will very often have the inquiring judge participating with the police and the prosecutor in putting together the case against the criminal defendant. In many ways, there are lots of people in the West, in the Anglo-American tradition, who find this just terribly disturbing and think it doesn't protect the rights of the criminal defendants at all, because there's judicial participation in the prosecutorial process. On the other hand, this procedure is definitely defended and defensible. It's defended by the people who exist in civil law systems, and it has worked, I think, extraordinarily well. And when you hear about international criminal tribunals, such as the one for the former Yugoslavia that sits in The Hague and the one in the International Criminal Court, one of the things you should know from the outset is that they have a marriage of our Anglo-American criminal procedure system and the civil law criminal procedure system. So even though you say it's extremely different and some people think it doesn't protect rights, nonetheless, nobody has suggested that it doesn't fit within the due process of law that's required by international human rights law. So that's a very, very brief background of what comparative law looks like. I do invite you to take a course in comparative law, either the basic course or the one I teach, Comparative Asian Legal Systems, when you're back in Washington for your second and third years. You have anything you want to add?
No, that's fine.
Okay.
The basic course we're going to be teaching in Rome is the International Human Rights course. And I need to say a few words about international law. First of all, that's a very modern term. The traditional label for this area of law is the law between the states, the law of nations. And that's what it was for most of its existence. It was the set of rules that governed how one nation state would be entitled to act with or against or for another nation state. And the primary rules of the law of nations were prescriptive. They came about through practice. And this is still a source of public international law. How nations behave with respect to each other, and when they do it with the belief that they are acting in accordance with law, and they do it in concert, and most nations do behave that way, that becomes a prescriptive law of international law. Now, Jeremy Bentham invented the name international law, and that's the name we use now, because beginning in the 19th century, and with a very rapid expansion after World War II, this field of, now we call it international law, deals with the rights and responsibilities of individuals. Initially, there was a law developed to permit one nation to override the general rule of freedom of the high seas and to stop a slave ship or a pirate ship anywhere in the ocean, and to free the slaves and to capture the pirates or the slavers and bring them back to their country and try them for crimes. So there, this field of international law began to deal with individuals. Well, we all know that the horrors of World War II showed a wanton disregard of the rights of individual human beings. Not just individual human beings within a particular nation state, but of all countries. And following World War II, there were the Nuremberg trials that applied retroactive, many would say, retroactive criminal responsibility to first the Germans and Italians who waged aggressive war in World War II, and then to the Japanese who had committed outrageous acts against individuals in Asia. The United Nations was the result of World War II. It was formed in 1946, and originally the thought was that there would be bills of rights in the UN Charter, just as in our Constitution in the United States. Our Constitution would not and could not be adopted until the Bill of Rights was added to it. And so in this country, we have the oldest bill of individual rights of any country in the world. But they apply primarily to U.S. citizens on U.S. soil. But the decision was made at the UN not to add bills of rights to the UN Charter. And instead, Eleanor Roosevelt the wife of the president, led an effort to adopt the international covenant of the World Covenant, Universal Covenant of Individual Rights.
Universal Declaration.
The Universal Declaration of Human Rights. And this was adopted by a unanimous decision of the General Assembly of the United Nations in 1948, I believe. And it has been so widely respected and used by so many countries in adopting their own constitutions that much of it is now regarded as customary international law.
Before we go further with what comes to be regarded as customary international law, perhaps we might backtrack a bit and talk a bit about how international law is formed, because most international law is formed by virtue of treaties. In other words,
Nowadays it is.
yes, nowadays. I'm not suggesting that it was initially, as you said, but now we mostly create international law through treaties, although we have customary international law.
Right. And almost all international human rights law is treaty law.
Right. But let's talk a bit about how treaties come into effect, how they are signed and ratified, and what those terms mean, and how a treaty, or let's say a convention, those are terms that are on one side, is different from a declaration by the General Assembly of the United Nations.
There are basically two kinds of treaties. There are bilateral treaties, and the world is full of bilateral treaties.
Extradition treaties, for example.
The United States has bilateral treaties for extradition or trade in commerce or many other things with countries all over the world. And then there are multilateral treaties. And these multilateral treaties may deal with things like the rights of air travel or the rights of postage between countries, very technical commercial things. But in our area of concern, modern human rights law has been the creation primarily of multilateral treaties. And they have been sponsored primarily by the United Nations, and the most important ones that we will study are the ICCPR and the ICCSER.
The International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, ICESCR.
And these take the rights that were described in more general terms in the Universal Declaration of Human Rights and split them into two pots, one for civil and political rights and the other for economic, social, and cultural rights. And it turns out that the former are much more immediately important because they have absolute and immediate application. The economic, social, and cultural rights are quite real, but they are progressive and to be achieved only over time, and they are still in the process of being fulfilled.
Now, with respect to the ways in which treaties come into effect, and obviously this is something that will be stressed in a variety of the courses in Rome, is that a nation can become a signatory to a treaty without necessarily ratifying it. It's only upon ratification of the treaty that the country becomes a member of the treaty, if you will, becomes a part of the treaty. And in order for a treaty to come into effect, at the very outset of the process, a specific number of nation states must ratify a treaty for the treaty to come into effect. So when you look at the dates of when a particular country becomes a party to the treaty, it will say the date of the signature, and then it will say the date of the ratification. And there are many other technical aspects of how treaties come into effect, but again, these are the kinds of things that we'll talk about more specifically in the various courses in Rome.
Once a nation has become a state party to a multilateral treaty, it is subject to all of the rights and responsibilities imposed by that treaty. It is bound, it is legally bound by that treaty, and it can be called to account in various institutions and organs, primarily within the United Nations or with one of the regional bodies. There are very important regional bodies in Europe, in America, in Africa, and we will be talking about those to some limited extent in Rome. But what's important is that there are international institutions and organizations, most of them not fully courts, but they are set up to adjudicate various claims and make various pronouncements that have great weight as authority, and we will be looking at those. And that's a very important source of the international law of human rights.
And then to differentiate between treaties or conventions on the one hand and declarations of the General Assembly on the other, I think it must be clear from what we've said so far that a declaration has no binding force in effect. It may become customary international law. In other words, it may develop that there's so much acceptance of it and so much practice according to it that it becomes customary international law. But it doesn't necessarily mean that the declaration is at the very outset customary international law. We say that it's only perhaps parts or all of the Universal Declaration of Human Rights that has become customary international law. I don't know of any other declaration of the General Assembly that has been accorded that sort of weight.
Now, there are a plethora of multilateral treaties dealing with human rights. Slavery, discrimination, rights of the child. I won't even try to list more than a handful of them. We'll be primarily studying the ICCPR and the ICCESR because they are the leading treaties. But the most important and effective multinational system for imposing and protecting international human rights is the European system, and we will spend quite a bit of time looking at it. But there's another important factor here. Almost all the multilateral treaties are set up to dovetail with the basic rules of the constitutions of the various countries and nation states around the world. And like the United States Constitution, you will recall that the Article 3 of the United States Constitution says that all treaties apply with the full force of federal law in the United States. They are superior to the laws of any state, and they are inferior only to the Constitution of the United States. But under the Supremacy Clause, treaties, and that's been read to mean all international law, both commercial and human rights, applies in the municipal, domestic legal systems and states of the United States. So every court in this country, in the United States, has an obligation under the Constitution to apply international law where it's applicable to cases before it. Now, here's the question of whether those multilateral treaties or bilateral treaties are self-executing or not self-executing. If they're self-executing, they apply immediately and fully. If they're not self-executing, then they require subsidiary congressional legislation or state legislation to become applicable. And that's a big, big topic, which we won't go into any further.
Right. And just so you know, I will assume that you weren't taking notes during this brief lecture, but you may want to go back and listen to it again. We're essentially done at this point. But we are also going to be distributing to our students a set of terms that are important for our examination. They are probably useful to other students in the program because they touch on a whole variety of different things like self-executing and non-self-executing aspects of treaties. So it may very well be that you'll want to receive this list of terms. I will be posting it to our TWEN, but if you're not in the class, you may perhaps write to me and to Professor Selecchia and ask that it be posted for the Rome summer program TWEN. And you want to add something otherwise? Okay.
Now you can see in just this short introduction, we've almost come full circle. What started out as the practice of nation states under what was then called the law of nations has become a fully articulated body of codified rules, codified in the form of multilateral treaties that apply through the various constitutions of various countries to the domestic legal systems of those countries. So to study public international law is not to study some ethereal thing that doesn't apply to us, but rather to study a field that has enormous immediate implications for all citizens of all countries.
So thank you very much. Very eloquent, Dr. Irish.
No, thank you, Professor Simon.